Hi, and welcome back. In this lecture, we take up the final part of our contracts module. We look at breach of a contract and the remedies that are available for that breach. Now, breach of contract occurs when a party fails to perform according to the terms of the contract. They fail to do what they were obligated to do under the contract. Now, there are two types of breach. The first being material breach, which your book refers to as total breach, and the other simple breach, which is a breach that is less than material. Now, the law also provides remedies when a party breaches a contract. Remember, every law has these two aspects of a right and a remedy, and it is a remedy that gives the contract meaning. Today we're going to examine breach of contract and the remedies that are available to the non-breaching party. First of all, what do we mean by breach? Well, when a party to an agreement owes a duty to perform and fails to fulfill that obligation, that party has breached the contract. And a material breach, total breach, as your book calls it, entitles the non-breaching party to either suspend performance or be discharged from further obligations. A material breach entitles the non-breaching party to sue for monetary damages caused by the breach. Now, material breach occurs when the breach deprives the non-breaching party of the benefit of the contract. Now, how can we determine whether a breach is material or not? What do we look at? Well, we look to see, first of all, does the breach defeat the purpose of the contract? Does the breach rob the non-breaching party of what it expected to receive under the contract? Secondly, when did the breach occur? And was the breach willful, meaning was it an intentional breach? Now, a breach that is not material constitutes what we call simple breach, or your book refers to it as partial breach. In cases of simple breach, the non-breaching party is not relieved from performing. This is the concept of substantial performance. That if it is a non-material breach, which occurs when a party has substantially performed, then the non-breaching party must fulfill its obligations under the contract. But as we mentioned, the non-breaching party can recover damages caused by the breach from the breaching party, even in cases of simple breach or partial breach. Now, there's also a concept called anticipatory breach. After the parties have entered into agreement, but before performance has occurred, it may be apparent that one party does not intend to perform as they agreed. Now, this could be through the party's words or through conduct. The law provides a recovery for the non-breaching party even before the non-performing party breaches the contract, or even before performance is due. It is possible that a party, once it has made it clear that they will not be able to perform, then that gives to the non-breaching party the right to pursue a remedy. Now, any threatened breach or any breach that appears to occur must be material breach in order for this concept to apply, anticipatory breach. Repudiation. When a party threatens a material breach, the other party can file suit immediately. It is treated as a present material breach. So if I am contracted to supply a company with certain goods, and I learn on the news that that company has declared bankruptcy, I am entitled to breach my agreement, meaning suspend any further performance on my part, and immediately sue for damages. So an anticipatory breach is treated as a present material breach for purposes of a lawsuit. And that ability to file the lawsuit springs up immediately, even though contract performance may be not due until months in the future. Now, modern courts have held that repudiation occurs in one of three ways. First of all, a statement by one party indicating an intention not to perform, or an action by the promisor that renders the party's performance impossible, meaning, for instance, in a sale of goods, that the promisor sold the goods to another party, and knowledge by the parties that one party may be unable to perform despite both parties' best efforts. Let's talk a little bit about monetary damages. And again, this is remedies. Once the breach has taken place, it is possible for the non-breaching party to seek a monetary award. Now, this monetary award, this money damages, is actually made up of three components. And those three components are compensatory damages, incidental damages, and consequential damage. Now, we're going to talk about all of these in more detail, but these three together constitute the monetary damage award. Compensatory damages plus incidental damages plus consequential damages. Now, before we explore what each of those mean, we need to talk about one other concept first, and that's called the duty to mitigate, because this duty will affect the damages award. And what this duty means is that when parties are in a contract and one of the party breaches the contract, the non-breaching party must do everything in its power to avoid encouraging damages and loss. And if a party can avoid damages with reasonable effort and without undue risk or expense, then they may be barred from recovery through a lawsuit. So in the case of a sale of goods, the duty to mitigate on the part of a seller, meaning the buyer has breached the agreement, well, the seller is then under an obligation to attempt to resell those goods to another party. That's the seller's duty to mitigate. Now, when a buyer has breached. On the other hand, when the seller breaches, meaning they have failed to deliver the goods, then the buyer has a duty to go out and find substitute goods, to purchase substitute goods. They are under the obligation to do so, and if they do so, then their damage award is going to be the difference between the contract price and the market price, the price they actually paid. And when it comes to calculating damages, one can be assessed the damages that could have been mitigated rather than the actual damage figure. And the duty to mitigate is this rule preventing recovery for damages that were avoidable. Let's turn to the components of monetary damages. Now, the first is compensatory damage. And what a compensatory damage award does is it compensates the non-breaching party for the injuries that are actually sustained. Now, this covers a broad spectrum of losses for recovery of actual damages suffered by the non-breaching party. Now, compensatory damages are an attempt to put the non-breaching party in the same position they would have been in had the other party performed as they agreed. So it is what we call the benefit of the bargain. So in sales contracts, compensatory damages are generally the difference between the contract price and the market price. Meaning, if I'm a buyer and I've contracted to buy t-shirts from you at $10 a piece, and you breach the contract as the seller, and I have to go out and I pay $15 each for the t-shirts, then I am entitled to receive from you the difference in the amount I spent because of the market price, $15, less what the contract price was. So difference between contract price and market price. Same way in the case of a buyer breach. The seller is under this obligation to resell the goods. And if when they resell the goods, the market price is less than the contract price, compensatory damages measure the difference between those two to compensate the non-breaching party for the injuries that were sustained. Now, incidental damages are damages caused by the breach. They are directly caused by the breach. They are the reasonable expenses incurred after a breach. And for our purposes, incidental damages are those costs that were incurred as a result of mitigation. So we know that parties have a duty to mitigate. So when a seller breaches and a buyer has to go out on the market and research and find additional items that may be more expensive than they were contracted to pay, obviously they're going to get the difference between the contract price and the market price, but they have spent time and money in going out to purchase substitute goods. And therefore, they have incurred those damages as well. So those are called incidental damages. The final component of damages are consequential damages. Consequential damages compensate the non-breaching party for foreseeable losses that were not directly caused by the breach, but which flowed from the breach. So an aggrieved party, the non-breaching party, is entitled to recover consequential damages if the damages are caused by unique and foreseeable circumstances beyond the contract itself. So to recover consequential damages, the damages have to flow from the breach, meaning the damages must be a consequence of the breach. Again, putting it in the context of a buyer and a seller, if a seller delivers goods late, that means that the buyer was not able to resell those goods to its own customers. They have lost the profit of the caused by the late delivery. So if the delivery was 2 weeks late, then the buyer has lost the profits for the 2 weeks they would have made had the delivery been on time in accordance with the contract. So lost profits are a great example of consequential damages. These are damages that would not have occurred but for the breach, the original breach. So they're not compensatory damages. They're not about loss of the benefit of the bargain. Instead, it's about damages which flowed from the breach. Liquidated damages are damages that the parties agreed to ahead of time. At the time of contracting, the parties can agree as to what damages should be in the event of a breach. Now, to be enforceable, the amount of harm caused by the breach must be difficult to estimate or impossible to estimate. So when the parties strike a deal in the contract for liquidated damages, it must be difficult to estimate the cost of the breach. Furthermore, to be enforceable, the damages must be directly related to the breach and to be a reasonable estimate of the actual damages that were incurred, meaning there must be some relationship between the liquidated damages and the damages that the non-breaching party actually suffered. And finally, to be enforceable, it cannot be a penalty clause. A penalty clause cannot be disguised as a liquidated damages clause. So that's monetary damages. Those are monetary remedies. Now we turn to equitable remedies. Now, in some cases, monetary damages may be insufficient to compensate the non-breaching party. So in these cases, a court can grant what we call equitable relief. And whenever you see that word in the law, equitable or equity, it's generally referring to fairness. What is the fair thing to do in this situation? Now, one example of non-monetary damages would be specific performance. And we'll talk about that in a second. But essentially what specific performance is, it's an order by the court to comply with the terms of the agreement. And then injunctive relief, which is a means of having the court order a party to do something or not do something. And then there's the possibility of reformation. Reformation means to amend the contract, to change the contract to what it probably should have been from the beginning. Let's talk about each of those in more detail, starting with specific performance. Specific performance is an equitable remedy where a court orders the breaching party to render the promised performance by ordering the party to take a specific action. Now, this remedy is usually only available when the subject matter of the contract is sufficiently unique such that money damages are inadequate. If I am contracted to buy a certain rare Ferrari sports car, and there's only 3 of these cars in the world, and the seller breaches the agreement, I cannot go out and find a substitute good. I cannot cover in that fashion. Instead, my only relief is for the court to order the seller to sell me the car. Now, where else do we see specific performance? Real estate contracts. Real estate is by its very nature unique, right? There's no other plot of land that is exactly the same as this plot of land. And so in those cases, a court may order specific performance. If I have contracted to buy a specific plot of land, and you breach that agreement and refuse to sell me the land, I cannot simply buy another piece of property, because that piece of property that I contracted for was unique. And so therefore, in a real estate dispute, a court may well order specific performance. Personal service contracts in which parties agree that a specific individual who possesses a unique quality or expertise central to the contract will perform the services. So if I contract to take tennis lessons from Serena Williams, I cannot get similar tennis lessons from anyone else. It's only Serena Williams. So in that case, the court may well order specific performance. Probably won't, but they could. And finally, reformation and injunction. An injunction is a court order to refrain from performing a particular act. For instance, if your neighbor is building a fence on your property, you don't have to let him build the fence and then sue for monetary damages. Instead, you can go to the court and ask the court to order the neighbor to stop building the fence and to remove whatever fence has been put in place on your side of the property. Finally, reformation. Reformation occurs when a court changes the terms of a contract by rewriting it to conform to the party's actual intentions. So reformation, which is sometimes referred to as equitable reformation, what it does is it puts the court in the position of drafting the agreement that the parties probably should have agreed to early on. This contract modification is the reformation. And so reformation is possible because a court has this injunctive power. And so when the court orders a reformation, it is essentially an order to the parties to draft a new contract, a new substitute agreement that's going to take the place of the original. So in conclusion, what do we learn today? A breach is a party's failure to perform contract duties. There are two types of breach, material breach and simple breach. Be able to recognize those on your test. And we know that courts can award monetary damages or injunctive relief. Thanks a lot for listening, and I will see you in the next one. Thanks.